Welcome, everybody. I think we've got numbers of people joining, but we're conscious of time. So welcome to our webinar on employers of record, redefining workforce management for a borderless future. I'm Anna Fletcher. I'm a partner in the Gowling WLG UK employment practice. And today I'm delighted to be joined by my fellow partners from across Europe and Canada. And I'd like to let them introduce themselves to you.
So good morning, good day, and maybe even good evening, everybody. My name is Annette Knod. I am based in Frankfurt, Germany, also a partner of Gowling WLG, and I'm heading the labor and employment practice here in Germany.
Hello everyone, bonjour à toutes et à tous. I am Gaëlle Le Breton, employment partner in the employment law and in the Gowling WRG Paris office.
Good morning, everyone. My name is Nina Gupta, and I'm a partner in the Employment, Labor and Equalities section of Gowling WLG, based in Canada.
Thank you, everybody. So before we get going, I think some sort of concepts here. So I think it's tempting to think when you're managing a global workforce across multiple jurisdictions that the concept of the employer of record as a resourcing model would be really similar, if not identical. But with so many employment issues, and I'm sure you'll recognise this, as you'll hear today, that's an assumption that just wouldn't be correct. We see difference across our respective jurisdictions, and there are risks when you come to use this model, which we'll be considering during the course of this session. For the purposes of the session, we've envisaged a scenario where your organisation has identified an individual that it wants to engage and in a situation where you don't have a presence in that particular jurisdiction. So a different situation to where, for example, you might be wanting to move an existing employee into one of our jurisdictions. So let's start with the basics. So Nina, what's an employer of record for Canadian purposes?
So in Canada, and I would venture to say in the United States, there's really three interrelated concepts. So when a company wants to hire someone in Canada, but they don't have a presence in Canada, there's really three ways they look at it. An employer of record is a company that is set up to be the formal legal employer for all government regulatory purposes. So this entity, for a fee, will essentially do the payroll reporting, do the tax remittances, pay the government insurances, do the year-end tax reporting, all of that. So from the government and regulatory perspective, and even the employment contract perspective, the employer of record is the employee. We'll talk about some other concepts like joint employer let alone, but that's the idea. Somebody steps in for a fee, becomes the legal employer for most relevant purposes. The day-to-day management, however, is done by yourself. The second concept, you'll sometimes hear them call themselves professional employer organizations, and sometimes the terms are used confusingly and interchangeably, which is they serve as your outsourced accounting and human resources department for Canada or the United States. So they will be your agent, effectively. You're the employer, but they do all the heavy lifting in terms of the government regulatory work, the remittances. And then there's a third concept that we in Canada don't use so much, but you'll hear from my friends Gaëlle and Annette, which is a temporary help agency where you essentially need some labor supply and they can supply you the labor. They are, in fact, the employer. They essentially source people, have a roster of people, and there's a number of companies who do that. And they are sometimes also used to onboard somebody you found, but you don't have the infrastructure or the presence in Canada or the United States to actually hire that person. So there's three concepts. Employer of record, however, is the legal employer relationship with the government. I don't know if that answered your question, Anna.
No, absolutely. I mean, from my perspective, Nina, talking to you about this in preparation for today, how attractive is this? Is this about a situation where you may be just appointing your first employee in a new jurisdiction? And who else might you want to be talking to?
So what I would say is all of these solutions are deceptively simple, because before we even get to hiring somebody in a foreign jurisdiction, we should actually have a great conversation with our tax accountant or lawyer about the legal implications. And this isn't a tax seminar, but there are real tax implications of hiring somebody, particularly if you're hiring somebody really senior in a foreign jurisdiction. And so it is possible to trigger corporate compliance issues inadvertently. And so, and the other thing that I would say is, no matter how great the candidate is, we have to be very careful about just saying, oh, I'll hire them as a contract, vendor. Like, I'll just hire them as a contractor and I'll ignore all the employment law issues. And in many cases, you as a company are running what I would call compliance roulette. You're hoping that you're so small that the government won't catch you. But as you grow, that's very difficult. And also, if you are worried about your reputation in that jurisdiction, you want to start off properly. You don't want to start off with a reputation of being loose with the law. So, never as easy as it seems.
And Annette, what about in Germany?
Well, it was very interesting for me to listen, because employer of records as a term does not exist in Germany. We don't even have a German word for it. Of course, and some people, by the way, have to Google, what is it? But there is a good news. We have solutions, and yes, we can realize what we just learned from Nina in Germany. We just have a different model. We use different terms for it, but I'll talk about it a bit later. But just, to once again, to repeat, employer of records, it's not really known in Germany.
The same in France, Annette. The concept of employer of record remains relatively unknown in France. And in our practice, the most comparable mechanism is portage salarial, a strange word for employer of record, which involves a tripartite contractual relationship, like in employer of record. But the portage salarial, or employer of record for the purpose of this webinar, is not very popular in France because it is highly regulated by the French Labor Code. A number of conditions must be met in order to be lawful, and one information really important at the beginning is that the duration cannot exceed 36 months. We will come into details later, but in any case, I just wanted to add that I fully agree with you, Nina. Before everything, and before conducting an activity in France, even through an employer of record, I have exactly the same recommendation: consulting a tax lawyer. And you, Anna? Yeah.
Yes, I mean, it's a little bit different in the UK. It's a recognized term, unlike you were explaining, Annette, in Germany, and essentially an arrangement where an organization doesn't have a presence in the UK. So sometimes the arrangement can be referred to as a PEO, or a professional employers organization. I have to confess, it's not an arrangement that we come across routinely, and perhaps we'll come back to some of that. So I think, sort of in summary, it's a concept which might have global application, but that's going to be really dependent on the jurisdiction in which your organization might be looking to operate. And as you've heard, there are distinctions in France, Germany, and perhaps the UK and Canada a little bit more aligned in terms of the concept. But for some organizations, it certainly looks like an alternative model that could be used where the organization wants to engage an individual, or perhaps a couple of individuals. And so that really brings me on to the next question, which is, do we have to use an employer of record?
I think, Anna, this is maybe the most important question. I can answer this easily with a no. There is no legal need to use an employer of records, because it is absolutely possible to employ somebody through a foreign entity. which can be Canadian, which can be US, which can be Italian, which can be Chinese, there is no need to create or to establish a company in Germany to employ somebody. I know there is always the risk of having a permanent establishment, but as Nina explained, this is not a tax seminar, but there are also ways to avoid this. But once again, clear answer, no legal need to have an employer of record or to use an employer of record.
Gail?
Yeah, exactly the same in France. A foreign company can recruit directly an employee under a French employment contract without having a local entity. And in practice, the employee will be mandatorily covered by the French Social Security scheme, and the foreign company will pay all French social contribution directly to a specific body. So as Annette mentioned, the answer is no. We don't need to use an employer of record.
And that's actually exactly as it is in the UK. And again, same issues in relation to permanent establishment and needing to take tax advice, but you do not have to use an employer of record. You don't have to have a presence. And perhaps that's one of the reasons why we don't come across the concept of employer of record that frequently. And in Canada, Nina?
Well, in Canada, it is sort of the same situation. So, however, it's the convenience. It's sometimes really, from an administrative perspective, really annoying to run a payroll for one person, pay deductions for one person. There are advantages and disadvantages of the employer of record. So, of course, you're paying a fee for it. And sometimes these employer of records are very large, and so they have to pay certain withholdings at the highest rates. They don't get the small business advantages that if you're a one or two employee establishment. But but the one reason why many people want to look at an employer of record is that although we do have some public health care, it typically does not cover prescription drugs or dental or ancillary healthcare practitioners such as physiotherapists or chiropractors. To get a private healthcare plan for one employee can be very expensive, and the employer of records can often pool the fact that they are servicing, 1,000 employees in order to get very advantageous rates. So that's often the driver for getting an employer of record situation. And so as with anything, there are some conveniences and advantages, and there are some disadvantages as well. So that, it is used, I think, more often here in Canada, particularly by Americans who are used to even using it for interstate compliance issues. And so they use it when they want to find a promising candidate in Canada, but aren't ready to open up an establishment here.
I think that makes a lot of sense. And that is sort of leading into this next question about, why would an organization want to use this sort of model in terms of its resourcing? And Annette, why might that be the case from your perspective?
Well, as I said earlier, Germany does not really know the concept employer of records, but of course we understand the need for it. And Nina just perfectly explained it, so I don't want to repeat what she said. Because, and in particular, if somebody has experience with German and maybe European social security obligations, this can be really not a nightmare, but maybe something really difficult to understand for foreign companies. So I personally and many others fully understand why there is a need and a desire to say, oh, I don't want to do this. So can please somebody else, and in this case, an employer of record, do this. So, and as I promised a bit earlier, I'd like to let you know, even though Germany does not know exactly the concept employer of records, how do we do it? We do it, and we have one single option of, honestly, and Nina mentioned it earlier as well, we use the so-called temporary employment agencies. There is a really nice word in German for it. It's Arbeitnehmerüberlassung. So in case somebody wants to practice some German, this is definitely a nice word for Scrabble. We have a lot of these temporary employment agencies, of course, in Germany. They usually have a pool of employees and they lease them or they supply these employees to other companies. This is really a common model, and this is, again, how we do employment of records. There are not really temporary employment agencies who only offer the concept of employer of records, which is why I'd like to explain a little bit how these temporary employment agencies work. And we have typically two situations. One is you or your company wants to send somebody or 2 or 3 or 5 employees to do business in Germany, or you have somebody already in Germany and you'd like to have that person doing business for you. So these are typically the two situations we have. What is very important to note is that the temporary employment agency, or what we call it now, employer of records, is employing your employee or your candidate. So this is the employer, and this company has all the employer obligations. That includes, in Germany, the obligation to handle the social security contributions. And unlike Nina described it in Canada, healthcare is included in the social security in Germany. So this is all handled by the temporary employment agency. And this agency now allows the employee to work for somebody else, and in our case, for your company, to do business. And then you have all rights to instruct that person. The person reports to you in your company. So although the person is employed by the temporary employment agency, you have the right to instruct, which I think is essential to do. As I said, the employer, the temporary employment agency, must obey all employment laws, which includes the need for a work and residence permit. By the way, we shouldn't forget that, which can be a tricky thing, We don't want to do an immigration seminar, but that's an important point. And as the temporary employment agency is the employer, it's their obligation. It's no longer your obligation. And I have a few negative aspects now to tell you. One thing is, in order to operate as temporary employment agency, you need a permit. Otherwise, you risk high fines. So this is why only do it with an official registered agency. And I have one other information that is really important. We learned from Gael that maximum length in France is 36 months. I can beat that because there is in Europe a battle. Which employment law is worse, French or German? And here Germany wins, I guess, because for us, it's only 18 months. So, which is a big downside, I would say, to use the concept employer of record, because that does not mean anything else than you only can use this person for 18 months. And if it's a highly qualified candidate, honestly, who would accept an employment for only 18 months? So I don't want to say again, we can't do it in Germany. But yeah, as I said, we have to respect a lot of rules, a lot of regulation, and flexibility is maybe not one of our key competencies.
Annette, so please be reassured because it's also 18 months in France for temporary contract. Okay, so we are on the same page.
Good.
Thanks to European legislation. Okay, 36 months is only for the portage salarial, so the employer of record. So one thing we learned preparing this webinar, so that we have a new concept in France, in addition to you, Annette. So 18 months for temporary agency, no doubt, it is European legislation, but 36 months for employer of record. Okay, so everything is fine. Okay, just for France, just one preliminary comment to your question, Anna. You may know that in France, because I think it's really important to understand this comment to better understand the concept of employer of record in France. Okay, you may know that in France there is a very big difference between self-employed status and employee status, right? Rights and social protection are very different. This is why historically the concept of employer of record emerged from the government's ambition to encourage entrepreneurship without its risk due to the absence of an employment contract and a social protection. So I think it's really interesting to understand the concept. But as I mentioned before, it is highly regulated, so 36 months. The duration of the service performed by the employee cannot exceed 36 months. And the client company shall only use an employee provided by the employer of record for the performance of an occasional task, that it is not part of the normal and permanent activity of the client company, which require a specific expertise that the client company does not have. So this is really important. So this is very often the case, of course, when the company does not yet have any activity in France. But it was important to clarify, just to better understand the concept in France. So having said that, my preliminary comment and history, since its creation, the concept of portage salarial, employer of record, has gained popularity in France. And we observed that the mechanism has sometimes deviated by company from its original approach. This is particularly true for foreign companies and investors who may not be familiar with French regulation, as you mentioned, Annette, for Germany, for instance, and who wanted to have an activity in France without the responsibility of having an employee. So we observed an increase of this type of request post-COVID. And I think that maybe it's the case for you, Anna, and Annette or Nina. Why? Because foreign company wanted to relocate employees in France, French employees who previously worked abroad. So these companies wanted to respond positively to French employee, to requests from French employee who wanted to return home. But at the same time, these companies did not yet want to become an employer in France. So the scheme has therefore been divided from its original purpose, but not without risk. And we will come into details later. But it was really important for me to explain this story of the employer of record in France to better understand the risk later.
That's
We're getting
Yeah.
some questions, and so I thought, and interesting enough, the first question was a question I wanted to ask, but I'm not sure if panelists can ask questions, so I'm really glad that the question was asked. So an anonymous attendee, in terms of that maximum limit that you have in France and in Germany, this anonymous person was saying, well, what if, we did the maximum length and the person kind of went on a leave or a vacation for, a month or so, and then could we restart that period after a break? That's question number one. My question, since I now have the floor, Anna, is a little bit broader, is once people sort of have hit that maximum, what are the usual ways if you want to continue that relationship? And I don't know if maybe we'll get Gaëlle to start.
Yeah, no, it's a really good question. No, of course, it's not possible to take holidays and to come back for another period. What it is possible is to have another, I would say, contract with another ground for that. I mean, go back to my preliminary comments. one of the conditions is to have a specific mission, not linked to the permanent activity of the client company. So the key question here is, the key issue is to be able to justify why there will be another mission, why there will be an extension of the first contract. Because it's possible to have another grant, another mission, another need, but we will need to justify, to explain in case of request, litigation, blah, blah. So it's not possible to extend the period, but it's possible to have another if needed.
Germany?
Yeah, it's almost the same answer, but it must be a long vacation of 3 years. Then you can restart.
Okay, that's a very long vacation.
And how do we do it? I mean, as Gael explained, you either use a different temporary working agency, or, and I'd like to encourage you, you just send your employee to Germany as your employee. So it's maybe the easier way, and to find somebody who handles all the payroll and all the social security issue for you. It's maybe easier to do that instead of looking for a different agency.
So it's truly a temporary solution while you figure out what
Yes.
you're going to do in the longer term.
Yes.
Well, thank you. Thank you for the question, and thank you, Gael and Annette.
Nina, what's the position in Canada with this concept of sort of employee leasing? Is it common?
So employee leasing is used, but it's rarely used for what we're talking about today, which is, helping a foreign company employ a Canadian. It's much more used to help with surges. So, you have a huge project and you need, 4 or 5 extra people, and they will, provide you 4 or 5 accountants or 4 or 5 bookkeepers or warehouse labor supply. It's not really used for what we're talking. I mean, legally it could be, and some of the companies that do true temporary help provision also have a division that does employer of record work. So if you approach one of these companies and they understand, they start thinking, okay, this is not really a leasing situation. Let me send you to our sister company and they'll help you better. One thing is with any temporary help agency, whether it's for you're hiring a foreigner, or you're a Canadian company hiring, Canadians, you have to make sure that they are properly registered in most provinces. This has been an area of abuse, which has been often used to abuse newcomers, so that they do not meet government requirements. And so the government has clamped down on this.
Thanks. I think in the UK, when we have the same experience in relation to, the post-COVID world of hybrid working, where people don't necessarily have to, be working for the company in the jurisdiction that company is located in. And we have the potentially sort of added complication of Brexit with more restrictions on immigration. So it's more difficult to get people into the UK. So from that perspective, I think there's quite a lot of common ground really on some of the reasons why this is an interesting and attractive model. It's really convenient. For me, I think the issue we have is that it's still relatively new. It's quite untested. It's a beautiful model in an ideal world, because the employer of record is the employer. You don't have to deal with all the aspects of the employment administration elements of payroll, tax, benefits, human resource tasks. All that sort of admin is taken away from you, and it falls to the employer of record to deal with that. And there are certainly companies in the UK that do offer this as a service, and you can see the benefit of the outsourcing of those functions. It's often pitched as one of the benefits of engaging an employer of record. So there are some caveats, though. We have the concept of temporary work agencies in the UK, known as employment businesses, and that is a highly regulated area. There are conduct regulations that need to be complied with. There are rules that benefit and protect agency workers, which are derived from the EU. Contrast that to the employer of record scenario, completely unregulated. So there's no requirement for any type of license or permit. So an organisation can operate as an employer of record, and there isn't that sort of legal framework within which, you know, you're operating. So I think, you know, for any organisation considering using this model, it's really important to do your due diligence to make sure that that employer of record is familiar with the employment protections that exist in the UK. I'm not going to try and beat Annette on this. We do have quite a lot of protection, probably not as much protection as applies in Germany, but certainly there are lots of restrictions that need to be considered. So things around pensions auto enrolment, minimum wage obligations, working hour limitations, right to annual leave, and so on. So quite a lot of sort of administration as well as compliance that needs to be considered. So in terms of the kind of challenges, so in this model, you know, who actually is the employer? And Nina, I'll put that question to you.
You're on mute, Nina. Yeah.
So yes, absolutely. So that is the important question. And so I would say that in Canada, that from a routine compliance perspective, the employer of record is the employer. So that's tax withholdings, social security payments. The government will go knocking on the employer of record's door for that compliance. But operationally, we have a concept of joint employer that is both a statutory concept and a common law jurisprudential concept. And so what that means is that if there is a problem, and for example, let us say that this employee in Canada alleges sexual harassment in the workplace by a visiting, you know, German or French manager. Well, the Canadian human rights tribunals and the courts would have no difficulty in seeing that even though the legal relationship is with the employer of record, the day-to-day de facto operational employment relationship is with the actual client. And therefore, there is a concept of joint employer, and then the joint employer could actually be hauled in front of our regulatory tribunals. We got an interesting question, which sort of relates to who is the employer. So I wanted to answer it briefly. There's a question from an attendee. Well, if we have an employer of record, let's say Canadian now in the United States, because this is a very common American concept, are there implications for that for immigration purposes? Now, this is not an immigration seminar. We'll grab our immigration lawyers and force them to do a seminar shortly. But the short answer, yes, particularly for L1 visas, if you're trying to do an intercorporate transfer and the legal relationship is actually with the employer of record, you may have some difficulties doing that intercorporate transfer. So if the ultimate plan is global mobility and using those types of immigration intercorporate transfer mechanisms, again, you should actually probably not only be consulting with your tax accountant, but also an immigration accountant as to whether or not using an employer of record will aid in that global mobility or not. And then we will pass the rest of the questions to our immigration lawyers to answer on the next seminar, I guess.
And Annette, the position in Germany?
Well, I can keep my answer short. It's very clear. The employer is the temporary working agency, or as we call it now, employer of records. Concept of joint employers is also not that known. There may be one exception, and it is in case there is a secondment. So if the foreign company wants to send somebody to Germany and wants to use the concept of employer of records, it may be that, you know, the foreign company keeps an employment relationship, but the main relationship is definitely with the employer of records.
Thank you. And Gaëlle, joint employment in France?
Yes, exactly. Joint employment, employers, or better, in France, co-employer. So it is a jurisprudential concept, co-employers. And here, I think that the key issue is the question of the link of subordination. You know, we can have a co-employer in case of link of subordination. But I think we will discuss later as regard, for instance, disciplinary issues, this kind of thing. But yes, definitely the same answer than Annette or Nina.
Yeah, it's interesting because the concept of joint employer is still relatively well, unclear, and there's very little case law that gives you any kind of concrete guidance. So it's not really a concept that we see operating in the UK. What I think does really interest me is this concept of who is the employer, and that's really where I think that this creates an enormous amount of risk. It comes back to the rights that employees have in the UK. The principal right, leaving aside discrimination issues, is a right not to be unfairly dismissed. And at present, if you're in the UK, you have to work for your employer for 2 years to acquire that right. But we have a raft of employment law reforms that are being introduced by the Labour government, and all likelihood we'll see autumn 2026 as the date on which that right to protection from unfair dismissal becomes a day one right. So this issue about employment protection and who is the employer is going to become, I think, particularly significant. We also have a situation where our employment tribunals, so that's our labour courts, they approach things in a very kind of practical way. They're not necessarily driven by what the paperwork might say. They want to look at the reality of the working arrangement, not the labels that are applied. And we've seen that in the context of the sort of tripartite agency worker relationship, where it's possible that a tribunal would imply that there's a contract of employment between the agency worker and the end user, even if there is potentially documentation in place that might suggest that the agency is the employer. And that's particularly the case where that arrangement is a sham. So we do know that there is a material risk of the employment tribunal looking at that. In terms of the kind of concept of employer of record, I've only been able to find one reported case in the UK, and that was from June 2024. And it isn't a case that involves a sort of final determination. It was a preliminary matter about whether or not our employment tribunal had jurisdiction to deal with a particular issue. And for those of you who are interested, the case is called Brown and Portus Global. And in this particular situation, Miss Brown was engaged or employed by Portus, but in fact, Portus were themselves engaged by a company called Techro Limited. They were a company registered in Ireland. Ms. Brown went to work as, I think, the chief marketing operator. She worked for Techro, albeit she was in the UK, and she reported to their chief executive officer, Mr. Hughes. And in that particular situation, the contract, there were several contracts for reasons which aren't explained in the judgment, but the contract contained no clauses in relation to governing law or jurisdiction. And some years after her appointment, during which time, she'd reported to Techro had dealt with her on a sort of day-to-day basis, she was actually made redundant. And again, for reasons that aren't specified in the judgment, she brought a claim for discrimination. And the question was, well, does she have the right to bring a claim under our Equality Act? And the Employment Tribunal went through its usual tests. They looked at, for example, whether they needed to imply whether there was a contract of employment with Techro. They decided that that wasn't a matter for them, that was a matter for the final hearing. But actually what they did do when they looked at the Equality Act, they looked at a concept called close connection. Did Ms. Brown have close connection with the UK? Absolutely she did, said the tribunal. So they said they had jurisdiction to deal with her complaint of discrimination. Now, I found nothing further on this case. So whether at that point the parties got together and decided that settlement was the best option isn't really terribly clear. But it raises those very good issues that need to be thought about right at the very outset about, are you actually setting yourself up to create a real difficulty for yourself if you use this particular model, particularly in the UK. So I think sort of going back to that point around day-to-day management, how does that work? How would that work in Canada, Nina?
Well, so in terms of the day-to-day management with the employer of record, usually in the agreement, there is an understanding that the client company, so the foreign company, will be responsible, but there are circumstances in which the employer of record has to be looped in, and this includes any kinds of disputes, changes to the terms and conditions of employment. The employer of record wants to be brought back in. And, one of our attendees has asked a really practical question. You go on Google and, everybody sort of pretend, can have a really nice web presence. How do you know who's a good employer of record or not? Because this question was asked with a UK slant, I'm going to ask you, Anna, if you have any practical tips about how do you find the right partner to represent you in the UK?
If you're looking at this model, I suspect a couple of perhaps more informal routes. It may be talking to your own HR networks or resourcing networks to see whether anybody has any recommendations. It might be asking the particular organization for testimonials from existing clients, looking really closely, I think, at the commercial terms. How much liability are they expected to take on? How much are they going to push back to you? So those are the sorts of things that I would be looking at. But I suspect that if there's a very poor record, that would come to the fore very quickly if you were to do a Google search against a particular organization. Just saying, social media and such like, we know that that information is out there. But I think use your networks. Ask for references if you like, and look at the commercial terms on which the engagement is being proposed.
I think I would say the same for Canada. I think your accountants and lawyers are really good good resources. We tend to be a little skeptical of employer of record. So if we're giving a recommendation, it means that they have satisfied our sniff test, if you will. You were asking about, just practically speaking, you were talking about the commercial terms, and one of the things that you have to know is those the indemnification terms that you may see if there are claims. And one of the things that you may want to consider, especially if it's a employer that is very well remunerated, is whether or not the EOR has employment practices liability insurance. That's really important, particularly in the States, I think, where there are very expensive claims, but also in Canada. And what you can find is employment practices liability insurance that the employer of record has obtained that actually also effectively covers the clients of the employer of record. So that's another factor that you can look at when you're trying to figure out who is the provider best suited to you.
Yeah, I think that's it's looking for the practical solutions, isn't it? What we do all the time. I think the whole piece around how you manage day-to-day performance and absence, disciplinary sickness is all really difficult, because if you think about the Porter's case, Miss Brown is effectively working for Checkrow on a day-to-day basis, but in terms of managing her performance or taking action or dealing with absence, for example, that would have sat with Portus as the employer of record in that particular case. And it may well be that, some employers of record really just don't want to get involved in that. So you need to ensure that, you've got very clear parameters. And of course, then there's the additional risk that you may have an employee who actually doesn't really want to engage with the employer of record because they don't perceive that organization to actually be their employer, whatever the contractual documentation says. So I think, we just need to be very mindful about how this works in practice. And I think that, the situation can be hampered because if the individual employee doesn't want to engage, there's also concern potentially on their part that, the employer of record doesn't have a particular sort of vested interest in their own health and well-being and so on. So it's very difficult to see how that sort of that is managed in practice. So I don't know, Gail, is there a common situation that arises in France where this creates a problem?
Yes, I think that again, the main issue here is the link of subordination. I mean, to whom does the employee answer in practice? I mean, it's really, really important. And this is why an employer of record in France, portage salarial, can only be achieved by employees who are highly autonomous and independent. I mean, on a daily basis, in the way they organize their work, their working time, and go back to my preliminary comment, sorry, they carry out very specific and fixed term missions. And this is why we have this highly regulation in France, because it's to not have a daily management on to give instruction by email every morning, every afternoon, to not have this kind of situation.
And Annette, do you have anything to add to that?
Well, I push back to our concept of temporary working agency. Sorry, I always have to do that because this is how we deal with these situations. And here the answer is hopefully clear. The daily management is clearly done by the company where the employee works. So whatever is needed, it's there. And maybe a fun aspect. Should that company have a works council? I mean, this is only for bigger companies, and it's not the case if you just send one employee to Germany, but just to let you know, even the works council would be competent for the employee who is sent by an EOR or by a temporary working agency to your company. So that's important to know. But let's always keep in mind that the employer is the temporary working agency. That means in case any disciplinary action is needed, and sometimes, this is necessary, something went wrong, a warning letter, even a termination, this must be done, of course, by the temporary working agency, because that is the contractual employer, as we call it. So daily management is in the company. All bad things have to be done by the employer, the temporary working agency.
So we get into the realms of dismissal. And in France, Gail, how would we be looking at managing the sort of dismissal of an individual here?
So here there is then an employee claims the existence of an employment contract with the client company, because we are talking about that, arise when the relationship with the employer of record is terminated, right? And just go back to the real employer of record in France, as I explained before, is inherently temporary, okay, for a duration of 36 months as a maximum. So termination in a real portage salarial arrangement, again, is generally not an issue, because we have a fixed term period, so it's not really an issue. But because it's not so easy in France, of course, if the rules governing the employer of record are not complied with, then the employee could claim that the client company, which gives order and directive, blah, 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 go back to our comment, is its actual employer, and that an employment contract exists between them. So if a court rules that there is indeed an employment contract, then the client company could be ordered to pay mandatory severance payment, damages, I mean, the full package as an employer. So this is right. This is why it is so important to really observe the conditions of an employer of record in France. And in addition, sorry to say that, but URSSAF, the French Social Security body office, could order a reassessment of the client company social security. So, this is why the employer of record could be an option, a solution, but is not without risk. And it's really important to fix the framework of the relationship at the beginning.
And Nina, what about in Canada?
The employer of record will be the primary target, but what I've seen in litigation, and it's all settled, is that plaintiff representatives and governments will name both the employer of record and the foreign company, essentially using that concept of joint employer related entities. And while they may not be related entities in terms of corporate law, they are related entities in terms of managing this employment relationship. Those cases have actually all settled for wise reasons, because nobody wants the full wrath of the court or the government. And I don't know if anybody really wants the full agreement to be exposed. There are risks. So this idea, oh, the employer of record is going to have all that liability, that is in reality not an issue. Sometimes, however, the real issue is, can the employee collect? Can the government collect? You know, if you're in a different jurisdiction, are they really going to pursue you? That's more of a pragmatic question rather than a legal jurisdiction question.
Okay. It's really interesting, because I think when you go back to, as I say, the only reported case I've found on this, you know, we've got a situation where Ms. Brown's redundancy was managed by the employer of record, but you've got to ask yourself, you know, if that's the situation, how are you, as the potential employer, if an employment tribunal in the UK decided you were in fact the employer, how are you going to be able to establish that you had a fair reason for the dismissal, that a fair procedure was applied? Because ultimately, if the employer of record is leading on all of that, you may well find yourself in a position where the proper processes and procedures haven't been complied with, and inadvertently, you know, you as the organisation who's engaged with the employer of record end up being on the hook for, you know, unfair dismissal compensation, or unfair dismissal compensation if, discrimination compensation if it can be shown that there's something discriminatory about the way in which the employer of record has acted. So very tricky, I think, for employers in that situation. And I think just being mindful of time, bringing this sort of rather sort of full circle, in terms of business protection and what we know in terms of post-termination restrictions and so on, you know, what can an employer do to protect their business if they want to use the employer of record model?
Are you asking me, Anna? I wasn't quite...
Yeah, I think so. Nina, if you want to kick off on that, given the similarities that we have between the UK and Canada.
So I give a piece of practical advice, which is, if you're using an employer of record in Canada, you should review not just the commercial agreement between the employer of record and the client company, but the employer of record's proposed terms and conditions of employment with the employee, with the individual, because their agreements may not actually protect you properly, and you may not be able to assert your rights. So you may want to make it as a condition of this tripartite agreement that the individual signs a confidentiality, intellectual property, assignment of rights that goes to you in particular. And there are cases where an employee has signed some kind of confidential, non-solicitation type of agreement, but the courts will determine it to be broad, because the employer of record, of course, has many businesses and many clients that are unrelated to you. You want something that is very tailored and specific, that you can justify as being a fair and reasonable protection. So our systems, I think, are similar. I mean, we consider ourselves to be a common law jurisdiction. So I do think it's important to have that agreement if you are in a highly sensitive type of job where you want to have business protection, intellectual property protection. You need to pay attention to the homework. And that means getting a Canadian lawyer, or if you're in the States, an American lawyer, looking at customizing an agreement for that one individual, which may sound expensive, but if that person has sensitive secrets, you want to be able to protect yourself there.
Thanks. I recognise all of that. And in France, Gail?
Yes, quite the same. I mean, relying on portage salarial or employer of record does not effectively protect the client's business interest, such as, for example, non-competition that could arise post-contract by the employee, unless the provision of the employment contract between the employee and the employer of record are revised, but in practice is really rare. It doesn't happen. And why? Because, and something may be interesting for you, but if the client company attempts to insert protective provision into the employment contract of the employee with the employer of record, it could create an indication of this link of subordination. You know, like it tried to enter into the relation between the employee and the company. So in case of litigation, it could be really a strong argument for the employee to build this link of subordination. So this is why it's really rare in practice to try to modify this kind of provision in the employment contract.
And Annette?
Well, I excuse myself that I repeat to say that the employer is the company or is the EOR, which means the client company, you must oblige your partner, the EOR, to implement certain clauses into an employment agreement. And knowing that the temporary working agency are usually large companies, it's maybe very difficult to do so, but I have good news. I'm not saying the legal situation is ideal in Germany, but a lot of the confidentiality and IP rights obligations I have read throughout my career are covered already by German law. So German law gives you quite a good protection. I'm not saying you don't need anything in addition, but it's, I would say the basic is covered. Situation is completely different after the contract. So post-contractual non-compete clauses or non-solicitation clauses. These are highly unusual in Germany for two reasons. One is the rules are very unflexible and you must pay a very high compensation for it. And once again, as the temporary working agency or the EOR is the employer, this employer must justify any post-contractual restrictions, which is in many cases simply not possible. So let's be realistic. You are okay covered during the employment. After it, it's difficult. Once again, it's easier if you employ this person.
And I think here in the UK, I mean, part of the issue will be the seniority of the person that you're seeking to engage and the extent of the legitimate business interests that you're trying to protect. Because, of course, there's no protection in relation to the legitimate business interest of you if you're using the employer of record, because it's going to be their legitimate business interests. And it's whether you can engineer a situation where, you know, we have a flow through or flow down of those obligations from the employer of record, who are then seeking to protect your legitimate business interests, or indeed, you know, having a direct side agreement with the employee. But of course, that of itself could lend weight to an argument that that individual is in fact your employee. So all of that needs to be considered, as well as who actually litigates. So, you know, lots of things to think about when you come to use this model, right the way through from the point of engagement through to the protection of your business interests after the relationship has ended. So I think, and I'd just like to thank Annette, Nina and Gail for such a helpful summary of the positions that apply to the employer of record type model in Canada, France and Germany. I think it's provided lots of food for thought and lots of considerations about how you might use the model where that is possible. Or indeed, of course, you might decide after listening to us today that you're not interested in using this model because of the complexities that it gives rise to. So I'd just like to thank everybody for their contribution. I think we are out of time, but also can I thank those of you who did ask questions, and we hope that we provided answers that got to the heart of the issues that you wanted to hear about from us. And thank you very much for watching and for listening.